appeal in the matter of Liverpool Victoria Insurance Company and Khan and others.
Well, may it please my Lord Master of the Rolls and my Lordships, I appear on behalf of the appellant, my learned friend Mr. Higgins, and my learned friends Mr. Goldberg of Queen's Counsel and Mr. Tong, appear on behalf of the respondent, Dr. Zaffer.
Yes, Mr. Wim, I apologise for coming in slightly late. We had matters to discuss.
My Lords, this appeal raises important issues concerning the appropriate sentence to be given to a medico-legal expert found guilty of 10 charges of contempt of court, and specifically whether the learned judge was wrong to suspend the 6-month sentence of custody, and whether the 6-month sentence of custody was itself too short, such that this court is obliged to interfere. My Lords, the issue is of obvious importance to Dr. Zaffer. It's also of considerable importance to the public, as there's a particular public concern recognised by Parliament relating to the fraudulent pursuit of whiplash claims. The medico-legal expert instructed in such whiplash claims is charged with a special role and has a special responsibility to act professionally. Contempt of the nature found proven here strikes at the very heart of the civil justice system, and it is especially important in those circumstances to mark the gravity of the conduct, not least to deter any such conduct in the future. My Lords, I propose to address the Court on the issues arising in the appeal in the following order. I hope we'll have 9 headings. Forgive me if that sounds ominous, but they will move faster as we.
Your junior did a very lengthy and detailed skeleton argument. Not quite sure who gave him permission to have such a long one to 39 pages. We're normally restricted to 25 in this court.
Your Lordship's right.
I'm hoping that he did get permission from somebody.
Well, my Lord, if not, then we pray forgiveness for having
yes,
produced
I mean, the trouble is when people, in one sense, of course, you always feel it's helpful for people to say as much as they want, but there's an element of unfairness. If one side thinks that they can simply ignore rules of that kind, it means they gain an unfair advantage over everybody else. And that's the problem. You have to have an equal playing field for everyone.
Lord, the 9 headings are, first, why the contempt by a litigant making a false claim is A, treated so seriously, such that B, save in exceptional or special circumstances, an immediate custodial sentence is mandated. The second heading is how contempt by a medico-legal expert involves a higher degree of culpability, or put another way, constitutes an aggravating feature by comparison with the position of a litigant contemner. Thirdly, the nature and extent of the contempts committed by Dr. Zaffer. Fourthly, the approach to sentencing adopted by the learned judge below. Fifthly, the mistake by Mr. Justice Garnham with regard to what I describe as the starting point. Sixthly, the correct approach to recklessness. Seventhly, the correct approach to the issue of delay. Eighthly, why the mitigation does not justify suspension of the custodial sentence. And ninthly, the proper approach to the length of the sentence for a medico-legal expert generally and in respect of Dr. Zaffer.
What about the proper approach to the appeal?
My Lord, yes, I'm proposing to weave that in, but I'm content to address the Court at any stage, but I will certainly be dealing with proper approach on appeal, my Lord. My Lord, may I start with the first heading, why contempt by a litigant making a false claim is treated so seriously and merits immediate custodial sentence absent exceptional special circumstances. Well, the first point I wish to make is the court is concerned here with a public wrong. And that is because the contempt amounts to an interference with the administration of justice. And can I take you to one of the bundles? There are two bundles of authorities. One I will refer to as the authorities bundle, and I think it's been so marked up. The other one is described as a bundle of decided cases, and so I'll refer to that as a decided cases bundle, if I may. I'm going to invite the court to the decided cases tab 5. It's a case called...
One of the things we're not going to be terribly keen on, if I can put it more like that, is being taken through a whole series of first instance
I do
decisions,
understand.
because they don't bind us.
My lord, indeed. My lord, I hope to make judicious use of the decided cases bundle.
Anyway, which case is this one?
My lord, it's tab 5. It's called Lane and Shah. It's a decision of the Divisional Court involving an exaggerated claim for which the sentences were 6 months, 3 months and 3 months. And for these purposes, can I just invite the court to paragraph 17, which is at P89. This is in the Judgment of Lord Justice Laws. I invite the court just to read to itself paragraph 17. Making false claims undermines the system of justice by putting a burden on insurers to try and work out which claims are false. And that's as set out in the South Wales Fire and Rescue against Smith case, to which there's been frequent reference. And whilst it's in 2 places, I've used Authority Bundle 9 for that case. That's the judgment of Lord Justice Moses. So that's
Can you what is, just summarise, if you would please, very quickly. I see this judgment that you just referred us to, Lane and Shah, is in the Divisional Court, the Queen's Bench Division. Can you just give me in a couple of sentences a summary of the background and how it came before the court there?
Yes, my lord. I did summarise it possibly in too short a form, but there's an exaggerated claim.
Yes. But how does it end up in the Divisional Court?
Because contempts come before a more senior court than a county court. They have to go to the High Court, and it appears that they will. So it's always going to be a High Court. Some of these cases are actually recorded sitting as a High Court judge. Some of these cases are Divisional Court with a Court of Appeal judge and another judge.
So was this contempt proceedings in the Divisional Court because they were proceedings in the County Court? Is that what it was?
My lord, I don't know that, but if we just go to the Lane and Shah paragraph 1, it's a judgment of court, it's an application for committal of the 3 defendants for contempt of court. It's brought with permission.
County court proceedings. Paragraph 7.
My lord, yes. I mean, a lot of these cases are modest whiplash claims.
All right, but then that's all I need to know.
Yes.
I just want to understand why
They have to come up to the High Court, and for reasons I'm afraid I don't know, they sometimes appear before Mr. Justice Garnham, or even a circuit judge sitting as a High Court judge, and sometimes they appear in a Divisional Court.
I got a vague feeling that nowadays circuit judges can hear contempt proceedings.
But they certainly have, as a matter of fact.
I think their jurisdiction has been extended now.
Well, my lord, they certainly have, because we have cases in here in which
That's all I wanted to know.
Yes.
Thank
my
you.
Lord, yes. The South Wales Fire and Rescue case is at Authority Bundle tab 9.
Yes.
And as set out at paragraph 3 in the judgment of Lord Justice Moses, they impose upon those liable for such claims the burden of analysis, the burden of searching out those claims which are justified and those claims which are unjustified.
So which paragraph?
Paragraph 3, my lord.
Thank you.
B, that means that honest claimants are put to task. my shorthand for the rest of paragraph 3. There is an impact, my lord, on the system of justice, see paragraph 4, which I won't read out, but invite the court to scan read. And actually, my lords, the matter goes somewhat further than that, and we see that from a very insightful judgment from Mr. Justice Lewis. And forgive me for the leaping around, but I'm back to decided cases. Tab 17. A case called Aziz and Ali. So decided cases, tab 17, my lord. Tab 17. My lord, that's a case, as you see from paragraph 1, where the accident never happened. In fact, there were two alleged road accidents. You see it in the middle of paragraph 1. For these purposes, I'd invite the court to paragraphs 15 to 17 of P186, in which Mr. Justice Lewis makes the points that the pursuit of these claims undermines public confidence in the justice system. The costs are ultimately passed on to honest drivers by way of increased insurance premiums, and that dealing with fraudulent claims involves the use of considerable public and court resources.
Why is it undermine public confidence in the justice system?
My lord, because the administration of justice, take care of the civil justice system, relies absolutely, as Lord Justice Moses says, on transparency, openness and honesty. You rely on, if you like, a presumption or assumption in favour of a person coming to court to perform their task, namely if they're a litigant, to give their evidence candidly and honestly, and we'll come to the position of experts in a moment. That's why it goes to the heart of the administration of justice. And there's a quote which I'm now going to take you to from Lady Justice Rafferty, which is a decided case 9, a case called the Queen on the application of London Borough and Havering against Bauer, where the point is made very effectively in answer, my lord, to Lord Justice Hamlin's question. That's another case of an exaggerated claim.
What tab?
My lord, it's tab 9, what I call decided cases, DC 9. And it's paragraph 16. May I invite the court to read that paragraph? It's a short paragraph. So, my lord, it offends against the system of justice. And my lord, the Master of Rolls has just made an observation in relation to fairness, viz. Timing or length of skeleton argument. How much more so where one party, as Lady Justice Rafferty puts it so graphically, mocks the concept by their arrogance and avarice, tilting the scales of justice in their favour.
Well, speaking myself, I don't really see how these citations go beyond paragraph 4, South Wales.
My lord, if they don't take the court further, so be it, but perhaps it's a matter of emphasis. My lord, the second point I wish to make is the making of false claims in road traffic accidents has been for some time of particular public concern. And can I take you again, and hope it's of value to the court, to another case in a decided cases bundles called Liverpool Victoria against Bashir, which is a decided cases tab 7. And this is a decision of Sir John Thomas, who was at that time President of the Queen's Bench Division. And this is a contrived collision, see paragraph 1. Paragraphs 9 to 11, Sir John Thomas references as under a heading the scale of fraud in the insurance market, and observes at paragraph 11 that a detection of such fraud is very difficult. Points that are echoed, and again forgive me if this seems only emphatic, but echoed, and I'll give you the reference at least, in a judgment of Lord Justice Elias at decided cases tab 23, called Zurich Insurance against Hooper. That was a case in which the defendant claimed to have been a passenger in an accident when he'd not been. And paragraph 43, at page P239, is to similar effect. Fraudulent claims of this kind are becoming very widespread. They are very damaging to the insurance industry, very difficult to detect. I invite the court to read the remainder of that, again, a short paragraph.
Yes.
And that has led to Parliament intervening through the Civil Liability Act, which is on the books, albeit not yet in force. And that is why Parliament converted modest whiplash injuries from 100% compensation ordinary common law principles to a tariff system as a direct response to Parliament's concern relating to the abuse of the bringing of modest whiplash claims. Hence, in our respectful submission, the need for an immediate custodial sentence as a mark of the court's condemnation and to deter such conduct. And here can I go back to the judgment of Lord Justice Moses in the South Wales fire case, which I picked out from Authority Bundle tab 9. Again, sorry about the jumping bundles. It's at paragraph 5. Those who make such false claims if caught should expect to go to prison. There is no other way to underline the gravity of the conduct. There is no other way to deter those who may be tempted to make such claims. There is no other way to improve the administration of justice. And C2 at paragraph 7. And again, not least when it's the judgment of Sir John Thomas, can I just take the court back to DC 7, to the London Victorian Bashir case, because the language used could not be clearer. Paragraphs 16, 17 and 21, so it starts at P99 of yours. See in the middle of 16 over the page, it's conduct which must be deterred because it strikes at the very heart of our system of justice. 17 again, must be deterred, and to that effect there is no alternative to a substantial custodial sentence. And 21, we would be failing in our duty to the public and to provide the necessary elements of deterrence if we were not to impose an immediate custodial sentence. So, my lords, suspension of sentence must be seen in our submission as something exceptional or requiring of special circumstances. Different courts can approach the word exceptional with different degrees of emphasis, whether it's used in exceptional or special, the point is the same. That is, we would respectfully submit the effect of the guidance of Lord Justice Moses, to which I've already taken the court. The contemnor should expect to go to prison, i.e. an immediate custodial sentence. And that is consistent with the long-standing approach of the courts to sentencing for somebody who interferes with the administration of justice. And that is what this is about. See paragraphs 3 and following in the Judgment of Lord Justice Moses. And for that, can I take you, I'm in Authority Bundle, tab 11, to a case called R against Montgomery.
This is a bundle of authorities then.
My Lord, Authorities Bundle, yes. I'm going to call it Authorities Bundle and Decided Cases Bundle. I hope that's satisfactory. Authorities Bundle, tab 11, my Lord. It's the Court of Appeal, and you can see just from the head note at C, save in exceptional circumstances, a custodial sentence is the only appropriate sentence for a person who interferes with the administration of justice. And this, as you can see over the page, at P156E to F, involved a witness to an offence against a person who elected not to give evidence. You see it at E to F, my Lord. And the relevant passage is at P159F, referencing a decision back in 1976, which is to the same effect, R against Owen. We haven't included it in the bundle, but I had a look at it, and it's a sort of virtual verbatim quote of what R and Owen says.
What was the nature of the interference here? It was the threat which precluded a witness from giving evidence.
It was, well, he said it was a threat. It's P156E. He reiterated his counsel he wouldn't do so because he was in fear, but he elected not to give evidence, and the court came down very hard on such conduct. Hence the approach. An immediate custodial sentence is required, save in exceptional circumstances. Lord, yes, the manner in which the administration of justice has been interfered with is different in that case, but the point we wish to make is contempt in this context is contempt which interferes with the administration of justice.
So I'm just trying to, I'm not familiar with these facts here. The prosecution wanted to call a witness.
My Lord, yes.
The witness said he didn't want to do so because he was in fear.
Yes, my Lord.
He said he had no evidence to give, and then there was an application for his written statement to be read out, and that was allowed, the judge being satisfied to the criminal standard of proof that he was indeed in fear. And so the contempt was that even though he was in fear, he
Yes,
shouldn't
my
give his evidence. Is that
Yes, my Lord, exactly. My Lord, it may or may not seem harsh, but it's because the wheels of the administration of justice require that witnesses, one, aren't interfered with. That's one form of interference with administration of justice. If you frighten a witness or threaten a witness who's going to give evidence, and two, witnesses who have produced statements in support of a prosecution need to attend to give their evidence for the criminal justice system to function properly. And the courts take these matters extremely seriously.
I may be wrong about that. That sounds to me as a special feature of criminal prosecutions.
My Lord, not in our respectful submission. Contempt in this context is actually a criminal contempt per Lord Justice
This is a
Morbick.
criminal contempt.
Per Lord Justice Morbick, Mr. Justice Garnham says it's a civil contempt. We didn't appeal that, but per Lord Justice Morbick, it's actually a criminal contempt. It's something rather.
We're talking about this case, not our case.
We're talking about this case. We're talking about contempt of this nature.
Montgomery.
You're talking about all these
So
cases.
We're talking about all these cases. We're talking about these types of cases, including the case of LV against Zaffa.
Oh, really?
Yes, ma'am.
But you haven't got an appeal on that basis, have you?
my lord, we have, for whatever reason, it hasn't been appealed, but my lord, lest your lordship thinks that one should be drawing a clear distinction, one's a civil contempt, one's a criminal contempt, I would certainly urge caution by the court before going down that avenue. The judgment is DC 11, decided cases 11, Airbus Operations Limited and Roberts.
One moment. Right, well, let's just take it stage by stage.
Yes, my lord.
You haven't appealed
No, my lord.
the issue of whether it's a civil or criminal contempt. So we are dealing, so far as this court is concerned, with a civil contempt.
On that basis, my
Yes.
lord, but I'm obliged to raise with the court.
But there's another issue, which is whether or not criminal contempts are dealt with in the same way as civil contempts.
Well, my lord,
Just trying to understand your point.
absolutely, my lord, absolutely. My lord, the first point is whether or not a party has made an appeal in relation to what Mr. Justice Garnham says, namely as a civil contempt. I would urge caution by this court, the Court of Appeal, in proceeding on what I might otherwise describe as a false basis. That's what I'm saying. My lord.
False legal basis.
False legal basis, for which I seek to draw the court's attention to that which Lord Justice Morvick sets out, paragraph 17, in a case called Airbus Operations and Roberts, DC 11.
Yes.
And lest my Lord the Master of the Rolls consider that Montgomery can be comfortably distinguished on the grounds that it sits over here in a category called criminal contempt and we sit over here in a category called civil contempt. The distinction between civil and criminal contempt was alluded to in the judgment of Mr. Justice Garnham by reference to a decision of the Supreme Court in which it was said that there's a very clear distinction, but it wasn't perhaps entirely straightforward from that to work out where the distinction lies. But the indication would be that where one is concerned with the interference in administration of justice, which is exactly what Lord Justice Moses says we are concerned with here, that is actually a criminal rather than a civil contempt. Civil contempt really being about making sure you comply with the orders of the court. But having said all of that, my lord, I would invite...
Just looking at paragraph 17,
Yes, my lord.
it says that the claimant must prove the defendant acted with the intention of interfering in the administration of justice.
My lord, yes. That's
Are we reading from that?
Paragraph 17.
my lord, yes, and that's set out in the judgment of Mr. Justice Garnham. That's part of the mens rea of what I might describe as the offence, but to avoid dispute as to whether it's criminal or civil, the
That covers
contempt.
recklessness, intention.
Yes, my lord. So the recklessness comes earlier. If you go to the judgment of Mr. Justice Garnham, so I'm now in what I would call the appeal bundle.
This is the main judgment or the...
My lord, yes. What I would call the appeal bundle, a small folder with skeleton arguments and the like, tab 9.
The passage you're referring to before is in 17 in this case.
My lord, it is. It's in the middle of 17. Do you see, your lordship see, about 5 lines down, contempt of court as a criminal offence. And in answer to the question from my Lord Justice Hamblin, at page 112 of the appeal bundle, paragraph 9, this is where Mr. Justice Garnham says a number of categories of civil contempt. He then references, after he's referred to the case I mentioned, the Supreme Court case of R. and O'Brien. He then says one's provided by CPR 3214, and that provides that proceedings for contempt may be brought against a person if he makes or causes to make, so A, a false statement, a document verified by a statement of truth, and B, without an honest belief in its truth. And you cannot have an honest belief in its truth because you dishonestly know it's not the case, or you are reckless as to whether it's honestly held. So that's how that comes in. And in addition, as he sets out at paragraph 10, it must be shown to knowing what you're saying is false. You have to have known that what you're saying is likely to interfere with the course of justice. Because that is what the court is concerned with. It is, in my respectful submission, but appreciating it's not an issue that's been appealed, actually a criminal offence.
So what Lord Tolson said in O'Brien, you were saying is wrong.
No, I don't think so, my lord. I think one doesn't actually sort of get it out of the O'Brien judgment. Doesn't sort of get an answer to these contempts. And certainly wouldn't be simply making submissions for the Court of Appeal that loosely that which the Supreme Court says is wrong. That would not be appropriate.
He says civil contempt is a contempt that's not itself a crime.
My lord, yes. It's something of a sui generis area. I say that because, for instance, when we come to the business of suspension and the like, it is not the case that the sentencing guidelines on whether to have a community order or a custodial order and whether the custodial order should be suspended apply. They do not apply. And that is because the Criminal Justice Act 2003, which gives the power to the court to suspend sentences of imprisonment by section 189, also provides by section 195 that a committal for contempt is not a sentence of imprisonment. So R and Montgomery involved a sentence of imprisonment under what I might call pure crime. Contempt of court is somewhat sui generis. The power to suspend is actually confirmed by CPR 81, but provided by the inherent jurisdiction of the court. It's CPR 81.29. The court making a committal order may also order its execution be suspended for such period or on such terms or conditions as it may specify.
But you were saying it is a crime.
Well, I'm doing my best to assist the court in relation to this issue, and yes, I am saying that although Mr. Justice Garnham said otherwise, and although it wasn't appealed, because it involves interference with administration of justice, Lord Justice Morbeck is correct.
I mean, you could say that everything is an interference with administration of justice. You know, when somebody doesn't obey an order, that's an interference with administration of justice. And what is it that falls outside that which the court does?
My Lord,
if you're making that as your distinction, I'm not quite certain at the moment where it begins and ends. The court process begins with the issue of the claim. It ends with the enforcement of an order. In one sense, anything which frustrates that, which is culpable behaviour, is an interference with the administration of justice. In every case, to a greater or lesser extent, it brings the court processes into disrepute.
My Lord, if I can put it this way, in one sense, the court's not wrong, but in another, that's a distinction which has been made. It's set out in Ireland on contempt. I haven't gone down this avenue. I prepared myself for the possibility that it might arise, but I haven't, because we didn't appeal it, given the court.
You raised it.
Well, my Lord, I sought to raise it because I could sense that the court might be concerned to say, oh, I'll put that in that category, but we're surely in the category of civil contempt. So that's where I take it. If the court would welcome a note from us trying to flesh out the issue after today, we would of course be pleased to provide
not
one.
very keen on written submissions after.
Well, only if it would assist the court, my Lord. If not, then not.
So let's take it stage by stage. Assuming we're receptive to your submission, that we should at least consider whether or not what we have in this case is a criminal contempt rather than a civil contempt. How does that affect the issues with which we have to deal on the appeal?
Doesn't go to the heart of the submissions I'm going to make. It's why I thought I'd leave matters as they lay, having from the time of coming into the case, would address the court if needed in relation to issue, but I simply sought to raise it then because the court may have considered it appropriate to make a clear division, and I would...
I mean, my only point on Montgomery, from somebody who has less experience than those on the side of you in the criminal cases, is it may be that in relation to the prosecution of crimes, the failure of a witness to give evidence has a particularly striking impact on our criminal justice system.
My Lord,
There's a particular there's a policy issue here.
yes, my Lord, precisely.
But that may be a particular, because one would have thought that, I suppose to a layperson, that if a witness is, as was found in that case, be genuinely in fear of harm or their life or whatever, to put them in prison when their statement could be read out would strike many people as quite a harsh consequence.
It's a harsh approach. It's a harsh approach to keep the criminal justice system working. Well, can I move on, because there are obviously strictures of time. Can I take the court to back to the judgment of Mr. Justice Lewis in decided cases 17? And that was a claim for an accident that never happened. I've already referenced that at paragraph 1. And paragraph 24. Counsel on behalf of Mrs. Salim submitted that personal circumstances of limited involvement were such that exceptionally a suspended sentence could be justified. I do not agree. And then gave an 8-month sentence. Decided cases 34, in a judgment of Mr. Justice Spencer, which involved an inflated claim, see paragraph 28 and following. Paragraph 40 and 41, Mr. Justice Spencer referred to his earlier decision, which is a decision that my learned friend has put into the authorities bundle called Aviva Insurance and Kovacic, where a suspended sentence was the outcome, and he continues at paragraph 41, that's P344. However, my judgment in that case made clear there were exceptional circumstances in that case arising from a 4-year delay, comes delay in due course. And I'll just give you the quote, if I may, from His Honour Judge Spencer QC in the case of DC8, which is called E-Sure Services in Ali at paragraph 31, where he described how a suspended sentence would be an act of extraordinary leniency. Now, my Lord, in relation to this issue, I believe there may actually be common ground with the respondent, because when one goes to the respondent's skeleton argument, so we're back into the appeal bundle at tab 3, external numbering, page 50.
Which paragraph in DC8?
In DC8, it's paragraph 31, my Lord.
Yes, Cameron.
My Lord, I'm now in the respondent's skeleton argument. I'm in the appeal bundle, tab 3, external numbering, page 55. At the top, which is actually paragraph 25H, respondent's written case, Garnham J was correctly submitted to take significant account of these lesser recklessness findings when deciding to suspend prison for Dr. Zaffer. This was an exceptional factor distinguishing his case from Mr. Khan's and indeed from other sentencing authorities. And to like effect, at page 64, paragraph 55, the appellant concludes that paragraph, by submitting that there's no such special feature that Dr. Zaffer can legitimately avail himself of, that too is wrong. It was a very special feature of Dr. Zaffer's case that of the 10 grounds proven against him, 9 were proven only on the basis of recklessness. So obviously I await then friends' oral submissions, but on the basis of what's set out in writing, it would appear to be some consensus that it requires of exceptional or special circumstances not to impose an immediate custodial sentence. My Lord, can I turn to my second heading, which was how contempt by a medico-legal expert involves a higher degree of culpability. My Lords, contempt by a medico-legal expert involves a breach of trust. That point expressly recognised by Mr. Justice Garnham in his sentencing remarks at paragraphs 10 and 11. I'll just give you the reference. It's AB, as in appeal bundle, 11, external pages 159 and 160. And just as in the case of, say, theft in breach of trust, that is an obvious aggravating feature. That's commonplace in the criminal courts. It could be theft, it could be all range of offences. It could also be said that the degree of harm.
So breach of trust vis-à-vis the court.
My Lord, yes, I'm going to expand upon that. Just making the headline submission, and I will seek to enlarge upon it, my Lord. Can I just make this additional submission first, please? It can also be said that the degree of harm is that much greater because a breach of trust by a professional at the heart of the litigation process has a highly damaging and corrosive effect on the administration of justice. And my Lord, in answer to the question from Lord Justice Hampden, the expert is in such a position of trust and at the heart of the litigation process because the parties and the court rely very much on the medico-legal expert in any and every personal injury claim. So it is not necessary to have a solicitor, not least in a low-value whiplash injury case. Litigants in person are entitled to bring cases and do in the small claims. But every person claiming to suffer from a personal injury needs a medical expert. Every case has to proceed through the conduit of medical evidence. And so the parties and the court are in a very real sense in the hands of the expert. That's why the expert is in a position of trust vis the parties and the court, both parties. Furthermore, in the context of modest whiplash injury cases, very often medico-legal experts produce reports on a prodigious scale, and Dr. Zaffer was no exception. And you see the evidence, it's paragraph 24 of the main judgment. I don't invite the court to turn it up, which is Appeal Bundle 10, page 115. He produced 5,000 reports a year. So the expert is thus in a particular position of responsibility with the opportunity to infect claims on an industrial scale. Put a different way, the medico-legal expert stands in a position of particular privilege and has further to fall. In other words, we did produce the insurance task force document. I don't think I can say it satisfies an ordinary Ladd-Marshall test because it could have been produced below. The only way in which it can go before the court, in my respectful submission, is on the basis that it's out there. It's a public document created and approved by government because it ends up being signed off by government. It's therefore accessible to the court. The court can take judicial notice of it. It's the only way in which I can sensibly approach it today.
What exactly do you want to rely on it for?
My Lord, it's a document which simply confirms that which I've said, that their costs within the system attract a small number of the so-called professional enablers, and it explains, very much along the lines of submissions already made, how the professional enablers stand in a particular position in relation to this litigation. The relevant passages were referred to in the application notice. I leave the matter there because I really would rather, my Lords, not use up my valuable time on that. It's a matter for the court, whether it seeks to take judicial notice of that public document created by a group of professionals and endorsed by government. And finally, my lords, it can be very hard to detect conduct by a medico-legal expert. And again, this is a case in point, as the learned judge found at paragraph 41, and that's Appeal Bundle 9, page 118, the position was only revealed just before trial when, in error, the original medico-legal report was filed at court and served on the other party. Otherwise, the position would never have been known. The only report, so far as the underlying defendant was concerned, was the revised report with the 6 to 8 month prognosis. My lords, the third headline submission is in relation to the nature and extent of the contempts which were committed by Dr. Zaffer. My lords, the first in time and the primary contempts relate to the production of the replacement report. And the circumstances leading up to that are all set out in a judgment. I'm in the court's hands, given the pressures of time.
You read the judgment?
Well, I'm very grateful, my lord, and then I would rather, if I may, skip through.
Just give us the references.
I will, my lord. Paragraph 25, so that starts at P115, and then para 29, 34, and the judge's analysis at 156 to 70. I will simply now draw out from that. This was a case in which the judge found at para 166 all that mattered to Dr. Zaffer was getting another report out. That's a quote. Hence his motivation was financial reward. And that is also set out in the sentencing remarks at paragraph 19, page 161, P161. And again, this is a quote. You were motivated first by a desire to keep the report writing factory you had devised running at full capacity so as to continue making the astonishing profit you told me about. And that astonishing profit was £350,000 per annum on top of his NHS salary. And that's main judgment, paragraph 151 at P140, page 140. So Dr. Zaffer's system was simply to allow his secretary to make changes without checking his work. That's para 166. He delegated the task to secretaries in circumstances where it was not uncommon for solicitors to ask Dr. Zaffer to consider amendments to his reports. That was para 164. Para 168, there was no attempt by Dr. Zaffer to investigate whether the amendments were clinically justified. He just did as he was asked by the solicitor. That's a quote. Para 170, not caring whether the court was misled or not. And if the court then goes back to paragraph 110, the email, and this was the email request to change the report, contained a bold attempt to suggest a prognosis. That was a prognosis Dr. Zaffer had simply adopted without demur. And the effect of those contempts was summarised by Her Honour Judge Walden Smith in her permission judgment at page 108. It's Appeal Bundle 8, tab 8, page 108, when she said, if there had not been that unforced error, that was the revealing of the first report, no one would have known that these two reports had been written, and the court would have been proceeding on the basis of the second amended report, which does not on the face of it appear to accurately reflect the examination that was undertaken of the claimant in that case. That could be seen to strike at the very heart of how the civil justice system works. So there, my lords, was a system put in place by Dr. Zaffer so as to maximise profit, by which he was prepared without demur to provide a revised prognosis, a matter obviously only for his own clinical judgment, as promoted by his instructing solicitor.
In this case.
In this case, absolutely. I fully take learned friend Mr. Goldberg's written submission that he's been punished for this case, not for alleged sins that he's not been proven to have committed. That the submission I've made earlier in relation to the opportunity is highly relevant when it comes to the deterrent effect of a sentence when people, medico-legal experts in small numbers, are in a position to infect on an industrial scale by their conduct. So many cases. Not least when the judge has made that finding of fact that I've referenced already, namely that he was asked often, or words to that effect, by solicitors to amend his reports. And we know that we know what his system was because the judge made actual findings as to his system, which was he simply delegated it to his secretary.
Just so I understand this.
Lord,
Are you
yes.
saying the judge said the system was that whenever a solicitor wrote in to change a report, Dr. Zaffer would just not paying attention to it? Is that what you're saying? Is that the system you're saying?
I will.
I mean, I know he did in this case, but you seem to be making a wider point about his general system.
My lord, I am making a wider point, but simply based upon that which is set out by the judge.
Where does he say that? Where do we get his
My
general?
lord, yes, it was para 164 that I took the court to. The court's kind enough at the first hole punch in para 164. Does your lordship see it was not uncommon, the first hole punch, for solicitors to ask Dr. Zaffer to consider amendments to his reports, and then continues, such a task would have been routinely delegated to secretaries. I've no doubt that if Dr. Zaffer required the secretaries to show him the amendments in draft, he would have had a system to ensure that happened. There was no evidence of any such system, and nothing to suggest that was the practice adopted on this occasion. And then you see para 166 that I've also quoted from. So, my lord, I don't say he's being sentenced for other than that which he's been found to have been in contempt for, but I do say this provides invaluable context. When one focuses on the important deterrent effect, see the judgments of Lord Justice Moses and Sir John Thomas, as he then was. My lord, second in time, I'm grouping the contempts, my lord. The first and most serious is undoubtedly in our submission in relation to the production of the amended report. The second in time.
And that's the only serious contempt that went to the claim itself, right? As opposed to sort of covering up the
That's exactly so, my lord. That's exactly so. What one's then dealing with is exactly that, the cover-up. And again, I'm only using the language of that the learned judge has used as opposed to my flourishing language. It isn't flourishing. I'll take the court through the passages of the judgments, because there are two, sentence remarks and the main judgment. So, my lord, yes, the second is in August 2013, when the existence of the two reports was put to Dr. Zaffer and he was invited to provide an explanation. And the judge's findings are at paragraphs 174 to 181 of the main judgment. And the judge made his finding that there was dishonesty because, see paragraph 178, he found that Dr. Zaffer had opened his file on the case and gone through his revised report before he saw Mr. Hayward. And that's the finding. So it's all set out at para 178, it's down towards the bottom. And that is why my learned junior has set out in the skeleton argument at paragraphs 18 to 21, which is pages 24 to 28, and precious of time do not allow me to take the court through that, set out how, whilst Mr. Justice Garnham made a finding in his sentencing remarks at page 161, paragraph 19, where he says at the end, as to one count of dishonesty, you corrected the error without admitting the dishonesty within 3 weeks. That too has to be put in the context that what he actually did was transferred his blame onto Mr. Hayward. And I won't take the court through a supplemental bundle and his various affidavits and statements that he produced all the way up to 2016 doing that, because my learned junior has set those out in the paragraphs that I've made reference to. And again, we totally accept the written submission of the learned friend Mr. Goldberg, that one's not so much dealing here with other offences that aren't before the court. That's not the proper approach to take. But one's dealing here with the extent of the mitigation that can be applied in the defendant's favour by reference to paragraph 19 of the sentencing remarks. And it is limited in circumstances where what happened is he said, well, okay, it wasn't med admin who made a mistake, because in October he starts saying he did produce the second report, and he then transfers his blame to Mr. Hayward for putting him under pressure in August 2013, all of which is absolutely rejected by the learned judge, who found Mr. Hayward to be a responsible witness. So, but I'll leave that, if I may, where that lies. And then the third in time, the third package of contempts, relates to the statement in October 2013. So we had the report in February 2012. It then emerges in August 13 that there was this first report. He then lies, he the defendant, in August 13. He then changes his tune in October 2013 by saying actually the second report's the right report and the first report was just a provisional report, or words to that effect. And that is described by the learned judge in paragraphs 182 to 187 of the main judgment. And that was all part of what the learned judge sets out at para 187 as a further attempt by Dr. Zaffer to explain the origin of the revised report. And quoting from the judgment at paragraph 187, this is P146, so it's in the middle of para 187. This is a further example, the court have this in the middle of 187, of the extraordinarily casual manner in which Dr. Zaffer approached the task of providing evidence to the court.
Do we have anywhere the actual allegations of contempt?
Yes, my lord, yes. And it is helpful to see them, yes. My lord, they're at tab 7 of the appeal bundle. And to have sort of clarity as to which ones... Yes, my lord. So it's the appeal bundle, the small bundle. My lord, at tab 7, but they start at P78, but relevantly they start at P85. Or I say P, page 85. And an easy way to know which ones were found is to also have tab 6, page 71 open. So just before, yes, my lord. If you keep one hand where that was, and also see 71, so your lordship see upon the findings against the third defendants, the third preamble paragraph. But I can go through. If your lordship then goes back to P85.
So on your first category, it's B17 to 22?
My lord, no, as it happens, as the way these have come through. If your lordship goes to 85, and what I did was asterisk the ones that have been found, asterisk 17 and 18, but I've written in the side for me October 13. So that's October 13. B18 is October 13. B19 was found and it's October 13. Then you go to B21, which is also October 13. Then you go to B22, which is October 13. If you then go over the B24 at the bottom of page 87, that's 24th of February 12. That's the revised report.
Hang on, we've got-
Sorry, my lord.
That's your category 1.
It is.
Where do you go after B22?
My lord, yes. After B22, B24. It
Yes.
starts at the bottom of 87,
Yes.
and your lordship will see that's February 12. And I've written in the side February 12. B26, February 12. B30, February 12. B31, February 12. And then B33, August 13. It's all set out in the judgment, but my lord, yes, it is much easier if you
That's
can.
the deliberate dishonesty.
Yes, my lord, and it is easier if you can see it in that way. But I could go through all of the findings, but I'm just for pressures of time, anxious if possible to avoid that. But the first and most important are changing a report from a 1-week whiplash, having seen the claimant and made that assessment and put it in writing, to a completely different case, namely symptoms are ongoing, he's still taking painkillers, his wrist will take 6 to 8 months and his neck will take 6 to 8 months. Your lordships have it. My lord, can I now address the fourth headline, was the approach to sentencing adopted by the learned judge below, for which I make 3 submissions. The first is that the judge highlighted breach of trust. I've referenced that, and we can perhaps open up the sentencing marks at tab 11. There are actually 3 versions of the sentencing remarks available to the court. I'm sorry about that, but I'm starting at page 157. That's the one that I've been using. And paragraph 11, you'll see at the bottom of paragraph 11, it's at the top of page 160, but you see your conduct in this case amounts to a fundamental betrayal of the trust placed in you by the courts. At the same time, in paragraph 11, you'll see in the first couple of sentences, those who make false claims should expect to go to prison, and that's after referencing the South Wales Fire and Rescue Authority. Solicitors and expert witnesses who act dishonestly in the evidence they give to the court, whether in support of such claims or otherwise, must expect a similar outcome. And can I emphasise that, because I'm going to come back to it as a ground of appeal. The second point to note is that the judge treated the worst of the contempts as a dishonest assertion in the statement of 20 August 2013. And we see that from paragraph 7, page 159. So it's the middle of paragraph 7. As the court see, the worst of these were the inclusion of untrue assertions in his statement of 20 August 2013, etc. These were deliberate lies designed to cover up what really happened. And paragraph 18 but the second part of 18, it's at page 161. I've actually drawn a line across. He addresses Mr. Khan from paragraph 13 all the way through to, it's paragraph 17, and then paragraph 18 over the page at P161, when he starts Dr. Zaffer every time an expert witness gives a report to the court, and the rest of that paragraph. Thirdly, the learned judge did not.
I'm sorry, I got the judge highlighted the breach of trust in his sentencing remarks. That was your first point.
My lord,
The
yes.
second point.
Albeit, he said you should expect a similar outcome, and I'll come back to that. It's all part of the first. The second is that he treated the worst of the contempts as a dishonest assertion in August 2013. I've taken you to the 2 paragraphs which my submission a good one that. The third submission is that although he did not set out in terms the reason or reasons for suspending the sentence, it's reasonable to infer that he had in mind principally the fact that 9 of the 10 contempts were found on a basis of recklessness, and to a lesser degree the issue of delay. And I'll take you to the paragraphs in the judgment, but before I do that, that would accord with the respondent's written analysis in relation to this issue. See paragraph 25G at page 54. The principal reason, this I'm reading now from the respondent's skeleton argument, so it's para 25G. The principal reason, therefore, for suspending the sentence against Dr. Zaffer was not the delay, but rather the learned judge's unchallenged finding of recklessness. So there would appear to be common ground again between the parties, that is how the judge made his assessment that the sentence should be suspended. And in terms of the judgment itself, because it's not set out in crystal clear terms, but paragraph 19 at page 161, lower down in that paragraph, he says, only one of the allegations I have found proven involved dishonesty. I found in respect of the other 9 that you were reckless rather than dishonest. And in the main judgment, in a paragraph that my learned friend in his written submissions takes to court to, it's paragraph 171, page 143. He says, accordingly I find, and those are the allegations relating to the revised report made out, it might be said that this was a less serious contempt than others which are addressed in this judgment, but contempt it was nonetheless. So the inference from those 2 paragraphs to be drawn is that he had very much in mind reckless findings as being the key to suspension of sentence. In relation to delay, see the sentencing remarks at paragraph 21, so that's page 161. In which the learned judge says, I've read the testimonials adduced on your behalf that speak to your competence as a doctor. In your case too, I bear in mind the delay that's occurred in this case. I accept that the fact that this has been hanging over your head for some years is a matter of which I shall take account. And he says, I've taken all these matters, so that's that, recklessness, obviously the whole facts of the case, into account in determining the appropriate sentence. And earlier, at paragraph 17, albeit in a section addressing Mr. Khan, but again it's common ground with the respondent, I believe, he says the delay was not the fault of LVI, and you contributed to it by your failure ever to admit your dishonesty. I believe it to be common ground that there was no delay attributable to the fault of LV. The delay was attributable to the fault of the defendants. We'll come back to my learned friend's specific submission in relation to delay when I get to it. So that's the approach to sentencing of the learned judge. And can I now turn to my 5th headline submission, which was the mistake or mistakes by Mr. Justice Garnham with regard to the starting point. My lords, the judge's approach was A, to treat the medico-legal expert as in a comparable position to a litigant. That was paragraph 11. And B, not to recognise that the default order was for immediate custody and that it would require exceptional or special circumstances to merit suspension of a custodial sentence. My lords, so far as concerns treating the medico-legal expert as in a comparable position to a litigant, I've made my submissions in relation to that issue already. The judge should have appreciated that the medico-legal expert's breach of trust that he identified constituted an aggravating feature rather than one that should lead to a, as he describes it, similar outcome. The way it was put in the grounds of appeal at pages 11 to 12, so that's the appeal bundle, tab 1, 11 to 12, was the principle in Smith, that's Smith and South Wales Fire and Rescue, should apply with greater rigour to an expert witness, and that the judge failed to attach sufficient weight to the strong public interest in an expert witness receiving an immediate and substantial custodial sentence.
So is there any case that supports that proposition? Or you say it's derived from a breach of trust aspect?
My Lord, I haven't drawn out the endless criminal cases, not least knowing the constitution of the bench. That's terra firma in relation to criminal law, that breach of trust is an aggravating feature. I mean, it's absolutely rock solid in my submission.
I think perhaps my Lord's question may go rather to your implicit proposition that but for the breach of trust, the expert witness and the litigant would be in the same position. But they're not in the same position, are they? For example, in a high-value claim, a fraudulent litigant might be looking to get £5 million out of the proceedings. The defaulting expert witness engaged on his behalf might have fees of £2,000 or £3,000. So when the learned judge was considering the respective positions of a litigant and an expert witness, might he perhaps have been saying no more than that the greater financial motivation of the one is, broadly speaking, balanced out by the greater breach of trust of the other?
My Lord, with respect, no, he's not saying that. That would require that sort of careful observation analysis that my Lord has just given, which is absent from the judgment. It's not what's been said at all. What he said is, look what should happen to litigants, see the guidance of Lord Justice Moses as approved, as we know, in the Supreme Court in Summers' case. That should apply equally, but no more, no less, to this case. He's not saying, I'm going to trade off one impact against another at all. And we see, and I'm not going to go through decided cases line by line, but we see that whether it's an exaggerated case in which someone has sought to benefit to a very large sum of money, or whether it's one of these concocted minor cases, and lots of them are only seeking, only in that context, £5,000 or a minor whiplash award, it doesn't matter, because these matters go to the heart of the administration of justice, but all the more so in relation to a person who sits in the special position that a medico-legal expert does. And he recognised that, but he didn't then attach the weight that he needed to that point. My Lord, so far as concerns the failing to appreciate the special or exceptional circumstances were necessary, there's nothing in the judge's judgment that would show he appreciated this. And there needs to be a recognition to that effect. It's set out again in the appeal, grounds of appeal at page 12, something to take Dr. Zaffer a distance away from the norm so as to justify suspension. He just doesn't say that. He says 9 of the 10 were reckless. He says, I take into account delay and I suspend your sentence.
But he recognised that the starting point was go to prison. So he was clearly consciously fighting from that, in contrast to his treatment of Mr. Clark. And he never said there are special circumstances here, but it's now really amounts to.
Well,
So clearly he is departing from what he recognised to be the norm.
My Lord, no. The special circumstances need to be identified, and it has to be explained what's special about those circumstances. You have to recognise that that's the threshold. I don't want to get into sort of evidential burdens, because it's a judge who's making these assessments. It's not litigation between the parties at that point. But if the judge see the sort of approach from Montgomery, save in exceptional circumstances, needs to impose a fortiori in the case of a medico-legal expert, an immediate custodial sentence, then the judge has to draw out what are the exceptional or special circumstances. I'm going to make submissions specifically addressing recklessness and then delay in just one moment. But this is if you like, a prior point in terms of the judge understanding the correct sequence that he has to go through, the correct starting point, as I call it. So, my lords, in terms of basis on which the court should interfere,
Can I just take up your point, so I can understand, arising out of paragraph 11
yes,
of
my
the
lord.
sentencing case, where you criticise the judge because you said he's equated an expert and a professional person like a solicitor with that of a false claimant. And although the judge goes on to say that they're, in their case, of Mr. Khan and Mr. Zafar, they play a special role in the function of the court system and what they did amount to fundamental trust, you say that he's equated them with a claimant, a layperson,
Yes, my lord.
whereas it should have been an aggravating factor.
Yes, my lord.
And then you sort of support that by saying, well, in criminal cases, betrayal of trust is regarded as an aggravating factor. But, I mean, we're not... I think the reasoning is quite complex because you don't have this analogy with false claims in a criminal context, do you? I mean, have you got a case in a criminal context which is evaluating, for purposes of contempt, somebody who makes a dishonest claim, and the sentence for those people, and the sentence for somebody who's a professional person? I mean, surely it must all depend on the context, mustn't it?
My lord, I wouldn't possibly suggest otherwise. Of course it depends on the context. The context here is you can have a litigant in person. Of course a litigant in person can do a great deal of damage, not least the observation of Lord Justice Holroyd is making a claim for millions of pounds or something of that nature. But we have endless fabricated collision cases. We're in the world now of minor whiplash claims. And a litigant can do so much damage. A medico-legal expert who is charged with an special duties, professional, lying at the heart of the litigation process. I've made these submissions, but they're very real. This is a person that you have to go through. If that person...
What I find surprising is we'll have to evaluate this. We're analysing word by word what the judge has said in paragraph 11. But, I mean, standing back from what you're saying, you seem to be suggesting that the sentence for Mr. Khan and Dr. Zafar should be greater than that for the person who makes the false claim.
Yes, ma'am. It's exactly the submission we
In
made.
all circumstances?
My lord, there were always... That's why I've called it a starting point. Because there were always particular circumstances one have regard to, and here we're going to have regard to the mitigation relied upon by the defendant and the judge. And I'm going to go through that mitigation to see where it takes the court. But before we get to the mitigation, this doesn't constrict the judge's discretion. This just informs the judge through guidance, which is why Mr. Justice Garnham says this was a case that merited appeal to the Court
Well,
of
to
Appeal.
me, all that he's saying here is that all of you should expect to go to prison, whether you make the starting point. Everybody should expect to go to prison, both the people who make a deliberately false claim and the people who are complicit in it. Well, I would have thought that was a fairly reasonable starting point.
My lord, I don't wish to raise this as a contentious example, but if there was a judge who was corrupt and contempt proceedings were capable of being brought against the judge, it would not, in my respectful submission, be right to say, well, you too should be treated like a litigant in person, because the judge of all the people sits in the most authoritative position with the greatest power both to deliver justice and to infect the system.
But all that shows it all depends on the facts.
My lord, this is a starting point. So I do say there is a gradation. There is a gradation. The court, in its capacity of recognising the need to deter this type and quality of public wrong should be recognising overtly, expressly, that medico-legal experts sit in a special position, submission I've already made, privileged position with further to fall.
So you're saying it's not simply an aggravating factor, that you should take a higher starting point.
Oh, my Lord, to me they're the same, but perhaps but for me, whether it's with, I've tried to use both sets of language because
Well, I mean, starting point was have a particular significance in the sentence.
my Lord, yes. When one is identifying the starting point in criminal sentencing, when going to the sentencing guidelines, for instance, in relation to theft, there is a category breach of trust, and it sets you off on a different starting point from those cases that don't involve breach of trust. This is not reinventing the wheel, in my respectful submission. This is an ordinary recognition by the courts that those with a particular position of privilege and authority and responsibility will meet a more condign deterrent punishment.
And you said what about solicitor? Is he in a more serious position because he's officer of the court?
My Lord, I'm not going to do a comparator with the solicitor here because save to recognise that the solicitor is in a more serious position than a litigant in person. The position is different, and this isn't a case of comparing. There's no part of the defence that says, or this appeal that says, by comparison to the sentence meted out to
I
Mr.
think
Carr.
this is quite, to me, this sounds like quite an important point, because you are saying, in cases of this kind, the starting point is that not only should there be a custodial sentence for both the dishonest litigant, claimant, and the expert witness, and it may be also the solicitor, but the starting point should be that the custodial sentence, should be greater for them. And that seems to be quite an important point of principle, which hasn't been formally been articulated by anybody.
Well, I hope so. I've taken your lordship to the grounds of appeal for that reason, to manage just such an observation. I've already
No, I appreciate that. What I'm saying is that you haven't referred us. You may be right. I'm not saying you're not correct. I'm just trying to understand the submission and the significance of it.
Is there an authority?
Is there an authority that actually says
this
that?
is the court. This is the court. It's why Mr. Justice Garnham gave permission, because we're coming to the court in a case in which we have, and we're not going to go through every single one, but we have a wealth of decided cases dealing with litigants, and in which we don't have cases dealing with medico-legal experts, and this is the first one where a medico-legal expert has been found, and they're difficult to detect, found to have committed these contempts of court, and we're now coming to the Court of Appeal to say we don't accept that the learned judge adopted the correct approach for a number of reasons, not least when you take the starting point, and this is the court that needs to determine that issue. And I hope to have provided reasons in support of the submission which we make, my Lord. So, my Lord, that is an important point. It's a mistake of law vis-à-vis the issue of on what basis should the court be interfering. It can be described also as an example of the judge erring in principle or leaving out of account a material factor. It doesn't. I mean, it's either way. It's relatively straightforward if the court's with the submission. And we've produced two authorities in relation to what's obviously wholly familiar to this court, namely its powers, but because the issue's been raised by Lord Justice Hamlin, right at the end of the authority bundle, tab 13, is the Court of Appeal case of Stewart and Goldberg, the facts of which do not matter in my respectful submission for these purposes, because we have a recitation at paragraph 81, page 204 and 205 from the then Master of the Rolls, Sir Anthony Clark, quoting with approval a judgment from Lord Justice Thomas, as he then was, with his add-on, which we see at page 205. So, an approval of the Audi Stores
I want
guidance.
to read
My lord, yes, it's really all comes together over the page. It starts on page 204, but when you get to the top of 205, interfere where the judge has taken into account, your lordship see that part, immaterial factors, omitted to take account of material factors, erred in principle, or come to a conclusion which was impermissible or not open to him, and then to that.
So but these are standard grounds
Totally.
for interfering with the discretion. Is that? Yes, I do want to ask you this question.
Yes, my lord.
Is that in this court, which is a court, civil court of appeal?
Yes, my lord.
Is that the correct analogy that we should apply in the case of an appeal against a sentence for contempt, either by one side or the other, that's analogous to a discretion where those are standard tests? Is that the same way we should measure? Because in relation to criminal cases, there's a slightly different formula.
My lord, there is. I was going to come to that, but I can address it now. The correct position, my lord, in our submission is as follows. This is not a case under the Criminal Justice Act 1988 in which gives a power to the Attorney General to apply to increase the sentence. The test is one of undue leniency, and the appeal court may interfere as a discretion as to whether to do so or not. That is set out in tab 1 of the authorities bundle, a case called AG's reference number 4 of 1989.
They go too fast.
My lord, yes, appeal, the authorities bundle, not the decided cases bundle.
Which
Tab 1, my lord. And my lord, if your lordship starts at page 2, the judgment of the Chief Justice Lord Lane, your lordship will see reference to section 36 of the Criminal Justice Act 1988. And your lordship will see what it sets out, which is if it appears to the Attorney General to sentence for a person proceeding in the Crown Court has been unduly lenient, then he may, with leave of the court, refer the case to them to review the sentence of that person. And on such a reference, the Court of Appeal may, etc. And that was all explained under the heading "The Correct Approach to Section 36" at page 5 at the bottom, and we've sidebarred it, or some. That's all my learned friends, but anyway, it has been sidebarred. And there is a very helpful between A and B explanation as to what unduly lenient means in these circumstances. The sentence is unduly between A and B, my lord. Is unduly lenient, we would hold, where it falls outside the range of sentences which the judge, applying his mind to all the relevant factors, could reasonably consider appropriate. Now, my lord, we do not say that that is materially different from the "it's wrong" test. Plainly wrong, see paragraph 81, the additional part from Sir Anthony Clark, back on page 205. In other words, you can err in principle and be overruled. You can take into account immaterial factors, not take into account material factors. Those all merit appeals. But if your decision is simply plainly wrong, whether one uses a language or borrows a language, and there's one Court of Appeal case I need to take you to, borrows the language of unduly lenient or not, actually doesn't matter, because the unduly lenient description there is no different from showing that the judge's decision is plainly wrong.
So that is equivalent to saying, as we would put it in civil appeal terms, that the judge has reached a conclusion in the exercise of his discretion, which no judge could properly have come to if they directed their minds to all relevant. So you say that's the same
It's
test.
materially the same, my lord. Now, I can just take you to one Court of Appeal case.
The other factors mentioned here are relevant to that. I mean, that at the top of the page in A, one wouldn't increase sentences simply because the court might have a different view. Sentencing is an art rather than a science. The judge particularly well placed to assess weight. That's all relevant.
Well, I'm not instance, I'm not going to say it's not. In that, of course, one always starts at the premise that the judge has heard the evidence and balanced into account all the relevant factors, etc. I understand all of that. But the art, not a science, is a flourish. I mean that critically of Lord Lane, which doesn't apply in a civil context.
I think that's the analogy with the discretion. That's the kind
Yes,
you know,
that's the court may.
That's the kind of the discretion. You've got a range of possible outcomes.
Well, my lord, if it's that, it's fine. If it's a discretion of the court on the basis the court may, in other words, the court doesn't have to interfere, that doesn't apply in the civil courts. If the judge was plainly wrong, this court must interfere. If the judge did not take into account material factor or erred in principle, this court must interfere. My lord, the case I needed to take you to was at tab 8. It's called Neal and Ryan. It's a decision of the Court of Appeal, judgment of Lord Justice Judge, as the M was. So it starts at P126. I'm again still in Authorities Bundle 8. And this was a case of a non-molestation order which was then breached by the ex-partner who attended at his ex-partner's premises and punched, as you see at the bottom of P126, very fiercely and injured her. And if you go over the page where it's been sidebarred, so this is a contempt case, then Lord Justice Judge explains, before considering an increase in sentence, I'm in the middle of that paragraph, or changing the impact of any sentence adversely to the defendant, we have to remind ourselves this is a power which must be used sparingly. The sort of circumstance in which it could be reasonable to use it would be to approach the problem as if the case were referenced by the Attorney General under the 1988 Criminal Justice Act. Plainly, it's not a case which comes within that jurisdiction, but a sentence shouldn't be increased under that act unless the court satisfies it's not merely lenient but unduly lenient. And I'll come back to that double jeopardy point right at the end of my submissions. And while we're on that judgment, can you kindly just stay on it on that page and go down to the last substantive paragraph, because in the middle of that, you'll see what we're satisfied about is that even if we approached the case on the basis the judge's view that 1 month's imprisonment was correct, it was wrong in principle for this sentence to have been suspended. So there is a classic case of Court of Appeal interfering or involving itself in a decision because as a matter of principle, it's wrong. It's wrong to suspend, and that's part of our case.
The first thing is, this case is binding on us because it's the Court of Appeal.
My lord, yes.
That's what the civil division doesn't really matter. And so, what is said in that middle paragraph
Yes, my lord.
really guides us in terms of the legal principles.
My lord, yes.
It's a power that must be used sparingly.
My lord, that is, I respectfully submit, something of an observation rather than the part of the ratio of the case. No, it shouldn't be used sparingly in the sense that there is a use sparingly test. The test is under Part 52 of the Civil Procedure Rules to analyse out, as I've already made those submissions, whether material matters have been left out of account, etc. Matters of principle proceed even the approach in the same judgment, or whether it's plainly wrong, and plainly wrong materially is no different from undue leniency, and even the language that Lord Justice Judge uses there only goes so far. I mean, it's carefully circumscribed. The sort of circumstances in which it could reasonably be used would be to approach the problem, etc. But I don't think...
I read, the trouble is the judge is using this word in principle, but as I read this judgment at the moment, that seems to me to fall within that part of upsetting a discretion,
Yes, my lord.
where you say no judge could properly have come to this conclusion. He hasn't identified here, as you've sought to identify, at least two respects in which you say the judge didn't fail to take into account appropriate matters. One, you say the starting point was different. That's your first, you say that's the first error of principle.
Correct, my lord.
The second one, you say, is that he didn't identify the exceptionality that's required.
My lord, yes.
So I'm just trying to interpret it all this now. So you're saying for those two reasons, if I call it this, the discretion was incorrect, and the Court of Appeal should exercise its own discretion to increase it in this case. I think you're also, I'm not sure if you're also saying, even if you're wrong on those 2 points, nonetheless, this is not a decision on the facts. This isn't a sentence which any judge could properly have arrived at. That's a different limb.
I am, but I'm saying more than that, because I just haven't got there yet. Because I make the very submissions that your Lordship has identified. I will then make submissions that there were no exceptional or special circumstances.
Well, that's the error of principle.
And I said, well, I said, it starts with the judge failing to recognise that that was a test.
Yes.
We then come to the application of the test, and on the application of the test, there were no exceptional or special circumstances, and then we come at the end to, in any event, whether one calls it unduly lenient or plainly wrong, the decision was indeed aggressively just so. So, my Lord, I haven't got that far.
In 2 respects, there were errors principles, and anyway, looking at all the facts, which include the fact there were no exceptional circumstances, it was wrong.
Yes, my Lord. I think in relation to looking at the facts, it's not just in its wrong. I think that's a.
It's wrong in the sense that no judge could properly write it.
My Lord, it's additionally wrong in the sense that no responsible judge would come to that finding, but it's actually wrong in principle.
No, I agree. I think I have said this. I understand what you're saying.
But it's an additional wrong in
Yes, no, I
principle.
understand.
I'm very good. My Lord, I'm just coming to that. So that's why I sought to make my 5th headline, only to go so far as to mistakes by Mr. Justice Garnham with regard to the starting point.
Yes.
And that, and forgive me for the confusion for his starting point, and my Lord Justice Hammond's right that, strictly speaking, if you go to the sentencing guidelines, we have to absolutely follow that, but we're not per se following quite that same chain. And to my mind, whether it's an aggravating feature or a starting point issue amounts to the same difference. But that's the starting point criticisms. But now we move on to principled criticisms relating firstly to recklessness. But I start that by headlining the correct approach to the finding.
This is point 6.
It is, my Lord. Which is reassuring, my Lord. Beyond halfway. My Lord, and they do get quicker. My Lord, the correct approach to finding of recklessness. In relation to this, can I make the following submissions? The judge failed to appreciate the seriousness of the first set of contempts relating to the production of the revised report, and I've already taken the court to the relevant passages. These were, in fact, the worst of Dr. Zaffer's contempts. And their toxicity was not materially reduced by Dr. Zaffer having been reckless rather than dishonest. And then the position was only made worse by his subsequent A, dishonesty, and B, reckless contempts in October 2013. Whereas the learned judge has sought to downgrade the overall quality of the contempts on a 9 out of 10 are reckless. It's just a wrong way to approach this case. The public wrong occurred when Dr. Zaffer chose to adopt proposed amendments by a solicitor, which had the effect of transforming his report, which should be based on his clinical judgment, from a 1-week whiplash to a 6 to 8 month whiplash. So that by his indifference to his professional obligations, Dr. Zaffer facilitated the promotion of a false claim. And recklessness in this context is just as much culpable as dishonesty. Dr. Zaffer was asked to ignore what he'd been told by the claimant and to replace it with a prognosis, preeminently a matter for his clinical judgment, provided by his solicitor, which he does without demur. That is an abrogation of his professional duties. Indeed, there's something rather callous about acting recklessly in that way. And worse still, he was motivated by financial gain. And I've taken the court to those findings of the judge. So as set out in the appellant's grounds of appeal, this is at pages 12 to 13 for the reference, and I'll just read it out. It was his choice as to how he arranged his working practices, and if he prioritised financial gain over his duty to the court, then his conduct comfortably satisfied the threshold for immediate custody and disabled the court from considering suspension as a legitimate response. And that is, in my respects of admission, well put, my learned junior. Furthermore, and this is the context, his conduct was in the context that he prepared reports on an industrial scale. And this is the finding that I've taken the court to at paragraph 164, that it was not uncommon for solicitors to ask Dr. Zaffer to consider amendments to his reports. So reckless indifference to what an expert will say is, it may be said, liable to lead to the production of more false reports than active dishonesty, which may be motivated on a more individual basis. The scope for damage to the administration of justice as a result of such conduct is very high. And finally, recklessness here suffices as a constituent element of the contempt for good reason. And that's, as set out in response to observations from learned Judge Justice Hamlin earlier, it's because CPR 3214 provides that the sin is in signing a statement of truth without an honest belief in its truth. So it's the absence of honest belief that's key. Whether reckless or dishonest, the medico-legal expert in this context has elected to set to one side his professional obligations to the court. And there is, in our respectful submission, something amiss in a defendant being able to rely upon the mens rea of the offence as itself mitigation, let alone mitigation that is described as exceptional or special. That would need to be extraneous to the actual constituent element of the offence.
I'm just trying to deconstruct this.
My Lord, yes.
In relation to this particular set of facts,
Yes, ma'am.
I understand exactly how you're putting your case in relation to the seriousness of the first act of contempt. I understand that. You say here the fact that it's reckless rather than dishonesty doesn't matter for all the reasons you mentioned. But now you seem to be going on to make a much more general comment about recklessness in the area of contempt, and saying it is because you're now aligning this to the signing of the expert's statement at the end of his evidence. He doesn't have an honest belief in its truth. That's a much more generalised comment about experts. Is that right? So this is an additional factor which applies not here but in other cases. Is that what you're saying?
Absolutely. Absolutely, Lord. What the effect of the judgment of Mr. Justice Garnham is, it is that medico-legal experts, and no doubt others, can attend in the future and say, but my conduct was reckless, that's an exceptional circumstance, can we now suspend the sentence? That's the effect. Recklessness is part of the constituent element of the contempt. The whole contempt, I mean, it says right at the beginning of the judgment of Mr. Justice Garnham, proceed on the footing of CPR 3214. It's paragraphs 9 and following of the judgment. And it does seem amiss to the appellant that a party can say, I've committed the offence, and ergo, without further ado, without further reference to something specific by way of mitigation, that constitutes an exceptional circumstance.
Right, but my understanding is, again, that in criminal cases, recklessness is treated as something which is less significant in terms of criminality than dishonesty.
My lord, there can be offences of specific intent and offences of basic intent. But if you're in an offence of basic intent, it's going some, in my respectful submission, for a party to say, I've met the requisite mens rea, which in that context incorporates recklessness, and on that basis alone, I have an exceptional or special circumstance applying. That's remarkable. That's
So
not...
You're not saying it can't be relevant to the level of sentence. You're saying it can't be an exceptional circumstance.
I'm saying it's going some, my lord, for that to constitute, and it's a night follows day. I'm in another case that the effect of this judge, and we'll have a judgment from the Court of Appeal, which will be read throughout in the world of contempt, and if the Court of Appeal is in effect saying, well, if you're reckless, that constitutes an exceptional circumstance.
If I may say so, Mr. Reid, with respect, you have slightly modified your submission over the last minute and a half. It did begin as a submission that recklessness as opposed to intent couldn't even be mitigation, let alone such exceptional mitigation as to provide without law a basis for suspension. I think you're now modifying that and acknowledging that there may be some difference in seriousness between he who acts deliberately and he who acts recklessly. But your core submission, as I understand it, is that in itself can never be a sufficient reason to suspend, precisely because it is one of the ways in which the contempt can be committed.
Well, my lord, again, it's difficult to go behind the observation which the court has made. I did start with using the word amiss deliberately, and have described being uncomfortable with, as opposed to wanting it to be so hard-edged as to say it cannot be taken into account, and I can't really improve upon the observation of the court in that regard. My lord, yes. My lords, can I then turn to the correct approach to findings of delay? May I make two submissions here? The first is the time taken from when the contempt conduct first came to light in August 2013, which the clock cannot start before then, because it was a hidden contempt, was attributable to Dr. Zaffer's decision not to admit any wrongdoing at any stage through to trial before Mr. Justice Garnham. The second submission is, such a lapse of time, being entirely of Dr. Zaffer's making, cannot be prayed in aid under the heading delay as mitigation at all. And I do make that hard-edged point. And then if and to the extent either I shift or the court disagrees, it certainly doesn't qualify here as getting the contempt law over the line vis special or exceptional circumstances. So going back to the first submission, the failure of Dr. Zaffer to admit wrongdoing at any stage, it's August 2013. I've given you the paragraph number, para 41 of the main judgment at page 118, when fortuitously the existence of the two reports came to light. Now, from that time onwards, as set out in sentencing remarks by the learned judge, at paragraph 19 on page 161, there was then, quote, by a cowardly desire to cover up what you had done. So that's the first sentence. It follows the, you were motivated first by desire to keep the report writing factory you devised running at full capacity, so as to continue making the astonishing profit you told me, and then by a cowardly desire to cover up what you've done. And we've seen how in August 2013 the first cover-up was a dishonestly blaming Med Admin for the production of the second report. There was then a volte-face because in October 13 it was a reckless suggestion the second report was accurate. And then, as I've already made those submissions, he persisted in blaming Mr. Hayward, and I referenced there the skeleton argument. I've given your Lordship the paragraphs of that. And you can see some of this in the judgment, paragraphs 178 to 179. and then through February 15 at paragraph 62, February 2015, and January.
178 to 179. There's a paragraph there.
My lord, 178 to 179 are paragraphs at page 144.
Yes.
That was the
August 2013.
August 2013, and Dr. Zaffer knowing that the report had been amended, see para 179. I have no doubt that by the time Dr. Zaffer saw Mr. Hayward, he knew that the report had been amended. And yet you'll see from his numerous sort of multiplicity of affidavits which were subsequently produced that he persisted in saying that he'd been confounded and confused by the conduct of Mr. Hayward. And you can pick some of this up in the judgment. Because
you remember it was paragraph 62.
I did. We sort of go back to paragraph 62 because we were there in the findings of the judge, whereas he was going through the history. And so you'll see para 62 references how in February 2015 the third defendant was required to disclose incoming emails. The whole thing was a rather laborious process of extracting the real truth as to what had happened, and it took time. And then you can go on to paragraph 65, and you get another of these affidavits. The 31st of January, the third defendant swore an affidavit saying he'd lost his handwritten notes relating to Mr. Akbal, that when making his statement to Mr. Hayward, he'd not been clear what Mr. Hayward had been talking about, and so on. And then if you go to paragraph 68, in a further affidavit in May 2016, the third defendant asserted as a result of specialist electronic investigation of his computer system, he now believed he had opened and saved a revised report on the 19th of August 2013, but it had been auto-changed, and what he actually says in his affidavits is that he didn't read through the report. But that's where the learned judge says, you did. You knew the report had been amended. See paras 178 to 179. So all these stages needed to be gone through to extract the real position, following which committal proceedings were then commenced in 2017 and heard in 2018.
So when are they actually commenced?
Well, it's slightly confusing, but there is the document that I took the court to before was at tab 7, page 75. It's actually got 3 dates on it: 23rd of March 17, 19th of May 17, and September 17.
So what's the correct?
Well, I probably the earliest date is when it was put into the system. It's a bit like a court order, which we have on a certain day and gets stamped about a week later, which is the date of the court order. I don't know. But my lord, you can see from the next tab on, tab 8, that the application for permission, which you need to bring committal proceedings, led to a judgment on the 21st of June 2016.
I mean, the important one's the date of issue, I think.
My lord, yes, well,
It's the 23rd of March 2017.
it would appear.
I think the stamp date of the 19th of May looks as though that's when it was assigned to Master Easton.
I see.
So it looks like it's
My
the
lord,
same
yes.
same type of stamp. The date on which I can't read the date on the.
Well, it looks like 12th of September to me, my lord, but it may be May. It's sort of
That's that may be when that again
Yes.
may be something to do with after it's been issued. Something
my lord, yes.
process.
Yes. But I've taken.
Permission hearing in May 2016.
My lord, yes. Well, June, I think, 21st of June.
So there must have been some application before that.
Yeah, well, the application, exactly as you say, page 96, paragraph 2, the application was heard on 24th of May, your lordship's absolutely right. So, yes, there needs to be an application. I don't think that's the claim form. Yes, the actual committal proceedings are then issued on 28th of March 2017. But yes, there is of course an application which is then heard in May 16, and for which we then get judgment in June 16. And I've already taken the court through how there's no indication of delay by LV. So what's happened there is simply having to unravel the realities of what happened, followed by the bringing of committal proceedings. The respondent doesn't suggest there was any delay attributable to the appellant's conduct. What it says instead is that Dr. Zaffer shouldn't be blamed for the delay because he was facing 16 grounds of contempt and was only found guilty of 10 of them, 9 on the basis, as it describes, of mere recklessness. And then the respondent's case is put on the basis that he had no other way to vindicate his position. And that's all in the skeleton argument of paragraphs 11 and 24b. That's the respondent's skeleton argument, paras 11 and 24b. My lords, with the greatest respect, that is an unrealistic stance for the respondents to take. At any stage, Dr. Zaffer could have admitted his failings as found. He could have done all of that long before committal proceedings were commenced. And when committal proceedings were commenced, he could have pleaded to the 10 grounds that he was subsequently found to have committed. And he could have provided, just as happens in a criminal basis, a basis of plea. He could have said, I'll accept that I was reckless in respect of these 9 and dishonest in respect of the 10th. Bringing contempt proceedings is expensive and time-consuming, and it's unrealistic to think LV would have continued in the face of such admissions if they'd been made. So the relevance of Dr. Zaffer avoiding 6 of the 16 charges goes to the issue of costs of the committal hearing. But it absolutely does not go to an issue of non-culpable delay. My second submission, the elapse of time cannot be relied upon as mitigation. It is delay after the admission of guilt that counts, not time elapsed as a result of a failure to admit guilt. And here the appellant asks the court to adopt a robust approach to this issue. And I'm going to go through some of the cases, because otherwise a contemnor benefits from contesting charges as a ticking of the clock during this time will then provide scope for mitigation, even to the point of qualifying as a special or exceptional circumstance, such as to suspend the sentence. And that is not the correct approach. Now, it is the case that there is the judgment of Lord Justice Moses in South Wales Fire and Rescue, and that has to be put into its proper context. Can I start with that judgment? It's at tab 9 of the authorities bundle, because it is a judgment in which Lord Justice Moses, having set out in such clear and trenchant terms the seriousness of the contempt, then suspended the sentence. What actually happened in that case, which we see from paragraphs 21 and 23, 22 rather, sorry, is that the original contempt occurred in 2007, and it was admitted, this is end of para 22, back in April 2009, and contempt proceedings were not brought until July 2010. In other words, it's admitted before the contempt proceedings. And then see paragraphs 23 to 24 of the judgment, which I'd invite the court to read. So, my lord, the distinguishing feature of that case, which is of critical importance when understanding what guidance it provides, it's a divisional court case, and we're now in the Court of Appeal in any event, it is that there was substantial delay after the defendant admitted his guilt. Can I take the court to the approach of Lord Justice Richards in a case in the decided cases bundle called Brighton and Hove against Brooks? And that's decided cases tab 6. This was another exaggerated claim, paragraph 6. By the claimant and the claimant's litigation friend. And can I go straight to paragraph 15 on page 94, please? Mr. Hogarth, that's the defence counsel, has suggested the lapse of time since the false statements and representations were made is a factor in the defendant's favour. But in our judgment it carries no weight, since it is of their own making. It is their persistent denial of any wrongdoing that has necessitated these long drawn-out proceedings for contempt. Just so, in our respectful submission. And the approach of Mr. Justice Supperston in a case at DC 28, decided cases 28, case called the Queen on the Application of Action to Exchange Limited against Broome and others. This was actually, see paragraphs 2 and 3, a group of employees of a company which sought dishonestly to reduce the value of the claimant's claims for hire of replacement vehicles. But the key players were not actually being charged with contempt, see paragraph 5. And can I invite the court to paragraphs 41 and 42? And can I invite the court to read those two, please? 41 to 42, page 293. This is the robust approach that we invite this court to expressly adopt to avoid delay becoming an attractive mechanism by which mitigation can be provided as a backstop in the event of not being able to defeat the proceedings but fully contesting them. And the judgment of Mr. Justice Spencer in a case called Atwell, which is at decided cases 34. That was another inflated claim, paragraph 28. And here it's at paragraphs 41 and 43. 41 to 43, one might say. Page 344. And finally, just 2 tabs further on at DC 36, and here's an example of a judgment of a county court judge sitting as a high court judge on one of these.
So when you said you refused to engage with proceedings, was that any more than denying?
No, I mean, it's para 36. It seems he actually refused to engage with the proceedings, as in didn't participate in the proceedings, I believe. But for these purposes, my respectful submission, that matters not. Whether one refuses to engage or chooses to deny and fight amounts to the same difference. You can't do that. You're perfectly entitled to do that. That's all part of the ordinary process of a claimant needing to prove his case for contempt against you. But you can't do that all the way through, as happened here, to a contested trial, and then pray an A delay. A as mitigation and B as mitigation that in any way gets near the exceptional and special threshold. Finally, the case at DC 36, my lords, AIG in Europe, that was an invented accident, and towards the end, 318 to 381, 382, paragraph 21. Down the bottom of 381 and over to 382. Those matters are your responsibility and no others.
What is the judicial guidance to which it refers? Is it paragraph 16?
I'm just looking at that myself, my lord.
Whilst you're looking at that, Mr. Weir, I wonder if your junior might be able to assist me, because my bundle stops at page 374.
Oh, I do
I'm obviously
apologise,
missing
my
at
lord,
least one of these cases.
Yes, of course, my lord. We'll pass you up straight away.
Thank you very much.
Number 36. My Leonard Junior has gone fully electronic, and it indicated that one difficulty with that is if the court asks for
Yes.
copying, and it's exactly what's happened. But
Thank you very much indeed.
My lord, yes, it's a reference to Bashir there. Bashir is a judgment of Sir John. Sorry, thank you. Sir John Thomas. I don't remember delay being featured. I would have taken court to it. That's at tab 7.
What do you... In that particular case, the custodial sentence wasn't suspended.
Yes, my lord.
Is that all you're drawing our attention to, the fact that there was this delay, but it wasn't suspended?
My lord, yes, I'm drawing attention to the approach that's been adopted by that judge, Mr. Justice Spencer, Mr. Justice Supson, Lord Justice Richards, and I am inviting the court to take a similarly robust approach, wherein they've said in very short order, the delays of your own making you cannot rely on as a mitigation. My lords, my eighth headline was why the mitigation does not justify suspension of the sentence of imprisonment. So, my lord, for this I take as a starting point that the contempt by a medico-legal expert is more serious than by a litigant, and that it requires exceptional special circumstances to support suspension. And as I've already made by way of submission, Dr. Zaffer's recklessness in producing his revised report, and then coupled with dishonesty and consequent recklessness, all as a desire to cover up his wrongdoing, it requires the court to mark its disapproval with a more, not a less condign deterrent punishment. And certainly cannot constitute key mitigation such as to justify suspending the sentence. The delay is of his own making, and the remainder of the mitigation was described by Leonard Jr. as formulaic, and it's not meant harshly, but there was nothing special. If one goes to mitigation that one might anticipate should be relevant by way of an exceptional circumstance or special factor, that will, in our respectful submission, ordinarily be strong personal mitigation, such as an early admission of guilt, true contrition, assisting in relation to the uncovery of further contempts. And I'm not going to go to the cases following the observation of the court, but there are examples of that, or significant harmful impact on others. And that's language which I've taken from the sentencing guidelines referencing when a case can be suspended, because that is classically, for instance, a young mother. One of the cases involves a young mother who was pregnant and about to give birth, Another involved a mother who had young children and was a sole carer. Those are the sorts of exceptional or special circumstances that may engage the court's applicant.
The first of those. What was the first of those?
The first example is strong personal mitigation would be an early admission and real contrition. And in one of the cases, assistance to uncover, because some of these are fraud rings, where as described, for instance, in the Bashir case, the defendants are foot soldiers, because people can be approached.
So is it assistance to what? What was the assistance?
Assistance to uncover the fraud, the wider frauds, because they can be a bit part player in a wider conspiracy or fraud.
Yes.
That's the sort of thing. That may or may not apply easily to a medical legal expert, but if it doesn't apply easily to a medical legal expert, so be it. And then a medical legal expert won't have that sort of additional mitigation. But a medical legal expert can admit his or her guilt at a very early stage. And the significant harmful impact on others is classic mitigation, which can be treated as a special factor. If, for instance, you are, one of the cases, I think, mother with children and a parent who was unwell and whom she cared for. I mean, that's where the court recognises the art rather than the science.
Is there not a fair distinction made between, for example, on one hand, let's say a dishonest claimant? I mean, I'm leaving aside from your point, the starting point is different for a lay claimant from a professional person involved in the litigation. In the case of a lay claimant, the effect of whose contempt is that they haven't got and haven't succeeded in getting the money they wanted, or they have to return it, whatever it may be. In this case, the inevitable consequence for Dr. Zafar is he's lost his professional standing, and he, we're told, has suffered financially hugely. He's had to take his children away from private school. So that here, the contempt itself has brought with it, or the discovery of the contempt has brought with it all these personal consequences that might not apply elsewhere. Isn't that something that the judge might take into account?
No, absolutely not. Absolutely not. Paragraph 6 in the judgment of Lord Justice Moses, it's the South Wales fire case, Authorities Bundle, tab 9. The public and advisers must be aware that however easy it is to make false claims, either in relation to liability or to compensation, if found out, the consequences for those tempted to do so will be disastrous. They are almost inevitably in the future going to lead to sentence and imprisonment, which have knock-on effect that the lives of those tempted to behave in that way, of both themselves and their families, are likely to be ruined.
Which paragraph is that?
Para 6, my lord. Page 128. That is an absolutely sort of sine qua non to this. If you're going to be convicted of contempt of court in these circumstances, it is going to ruin you. So he's lost his £350,000 a year practice, as a consequence of which his children have come out of private school. Yes, that's right. That's a consequence of committing these contempts. But whether he goes to prison or not doesn't change. He's lost that job. He's lost that work. That is an inevitable consequence. Again, that would be to pray and aid the ordinary as exceptional. That's bound to happen. The consequences are always going to be disastrous. He may or may not be struck off the GMC. It can't be said. I don't believe he has at this stage. I'm not sure. We're not aware he has. He may or he may not be. That's a matter between him and the GMC. But that's part and parcel of a professional in a privileged position has further to fall. But what this court needs to do is to provide deterrent punishment. My Lord, final headline was the proper approach to the length of sentence for a medico-legal expert generally and for Dr. Zaffer in particular. There is some guidance in relation to the starting point for a litigant who makes a false claim, and that's provided by Sir John Thomas in the Bashir case, which is in the decided cases at tab 7. Paragraph 18, under the heading, the appropriate sentences. And this was a case of a contrived collision, as I've already submitted. It's paragraph 1.
Which paragraph?
Paragraph 1 says confirms it's a contrived collision in which they were foot soldiers, see paragraph 16. And the relevant paragraph now is paragraph 18 under the heading, the appropriate sentences. When we considered the matter prior to the provision of information by the first and second defendants, we had in mind sentences well in excess of 12 months imprisonment. And then you'll see how they've taken into account, first, the admissions by these defendants of their fraud, and second, of even greater significance, their willing assistance to the insurer by the provision of the information that's been put before us. Now that 12-month, in fact it says well in excess of 12 months, starting point was adopted by Mr. Justice Bean, as he then was, in a case at DC 16 called LV and Thumber. And that was so it's decided cases tab 16. That was another faked accident. See paragraph 10. It's a bit difficult to draw it out from the recitation of the facts. Doesn't come out comfortably, but it's sufficiently clear from reading the whole of paragraph 10. And then the approach of Mr. Justice Bean at paragraph 18, going back to Bashir, where the fraudulent claim was confined to the bracket of £5,000 to £15,000, the President said that prior to admissions and provision of helpful information by the first and second defendant, the court had in mind sentences of well in excess of 12 months imprisonment. In my judgment, in the present case, the sentence is one of 12 months imprisonment. So that's...
These are both contrived claims.
Yes, my lord.
In the AIG case, it suggested that exaggerated claims fall slightly lower bracket.
Well,
Did we get that from Bashir? Or?
my lord, that might come up against the observation of my Lord Justice Holroyd that there's more to be gained from an exaggerated claim than there is from somebody's bizarre to contrive a claim and only to seek to recover a few £1,000s. These people in a ring may only just be paid a set amount of money and then have to hand over the judgment sum. But my lord, that degree of finesse, I'm not going, my lord, may I sidestep on this basis? The court doesn't, as indicated, it doesn't welcome me trawling through a line by line how each judge has approached each set of facts. My core submission is that there is guidance from Sir John Thomas, therefore to be noted, as Mr. Justice Bean did, in that context of a litigant in person in a contrived small value claim, in excess of 12 months is treated as a starting point. For all the reasons I've made submissions already, we say that and more should be the position because we're engaged here in a breach of trust. The court is bounded by the maximum of 24 months. It's a 2-year jurisdiction for a sentence.
Mr. Weir, is there any significance in the fact that you've dealt with these last 2 points in the sequence suspension first, length of sentence second?
Yes, ma'am.
Normally, of course, it's the other way around. One determines the appropriate length of sentence, taking account of all relevant features of the case. And then, certainly in the criminal context, the last question is, can that sentence of that length properly be suspended? Are you implying there's a different approach to be taken in contempt proceedings?
No, my lord. I'm not implying there is a different approach. I'm certainly putting our case first on the basis the suspension was wrong in principle.
Right. All right.
Secondly, in relation to the length of the sentence.
Yes, I see. Thank you.
But not intending to confound the ordinary approach that would be adopted. And so if the court accepts the earlier submissions, such that the judgment of Mr. Justice Garnham has to be set to one side, the court would be invited to go through its ordinary process. Absolutely.
All right, thank you. That's very helpful.
But that's why, my Lord, I'm to be open with the court as to. So, my Lord, we either reach this point, as I say, because the court is exercising its discretion afresh, or if not, because the court is questioning whether there has been plainly wrong or undue leniency, tests being materially the same, in relation to the sentence, both as regards suspension and as regards duration. My learned friend has...
Basically, you're saying, for one reason or another that you've gone through, we should set aside Mr. Justice Garnham's order.
Yes, ma'am.
There's no question of us remitting it to him. There's no point in
No.
that. So we should then exercise our own discretion, and in doing so, we should follow the normal route of saying, well, what would be the appropriate sentence of imprisonment should it be suspended?
Absolutely.
But presumably, having said he shouldn't have suspended it, if there's an error there,
Yes,
it's unlikely we'll get to that stage.
I have to take it through in a certain order.
So really, the only question of this would really be the length of sentence, I think, realistically.
Yes. My Lord, resentencing at a higher level does not offend against the principle established in a case that my learned friend has set out as being referred to in his skeleton argument, which is AG's reference number 33 of 1996, which is a case the court will find in the authorities bundle at tab 3.
I see the time. How much longer are we going to be?
My Lord, I do apologise. Almost no time at all.
So we should finish then now. Carry on until
I would ask the court if it would be kind enough to
Yes,
let me finish, my Lord. It would probably be
This is the
convenient.
double jeopardy point, is it?
My Lord, just before the double jeopardy, there is a case called Attorney General's Reference number 33 of 1996. It's at tab 3 of the authorities bundle. And for these purposes, I'm just going to go straight to page 19, where it's been sidebarred. And you see the last paragraph. That brings us to the question of how we should exercise our discretion. In our judgment, where an offender who has a viable defence has entered pleas of guilty, having been properly advised as a sentence which he was likely to receive, that is to say, offered advice in accordance with a tariff.
Page 19. No, I was finished on page 18.
I'm on page 19 of the authorities bundle.
Page 19 at the foot.
Oh, on the
The
foot.
next tab.
Yeah.
Sorry, Lord. Tab 3.
Which paragraph?
The last paragraph of the judgment, my Lord. Can I invite the court to read that paragraph?
It's the change in tariff.
It is, and you see it at page P15. The first paragraph in the middle, you'll see how it says that gives you the sort of granular detail as to what actually happened. They went to the judge, and the judge gave an indication based upon guidance that it was at the top of the bracket for manslaughter on any view, on which basis the offender chose to plead guilty. And what the Court of Appeal cannot do in that situation is then say, well, actually, we think that this needs to be marked with more serious punishment, because that person, it's like a legitimate expectation position, has a legitimate expectation that he has pleaded guilty to an offence for which he'll be charged according to the tariff at that time. That simply doesn't bite in relation to this case. It's simply an appeal at which we say the judge, with greater respect, got it wrong, and that difficulty or problem is not engaged. Finally, in relation to double jeopardy is addressed by the Court of Appeal in the next tab, Attorney General's reference numbers 14 and 15 of 2016. And it's all set out, helpfully produced by my learned friend, this authority, in which it's all set out at P38. Well, it starts at P37, but it's really at P38 where it's been sidebarred. And you'll see at paragraph 60, thus having regard to double jeopardy is but one aspect of the task of this court, through considering in the exercise of its discretion whether and how to intervene where the unduly lenient sentence has been imposed. Where a defendant has had no responsibility for the fact that he's been given a sentence which is unduly lenient, etc. Well, our first submission in relation to this is, here is a defendant who has chosen to mitigate on the basis that his sentence should be suspended. Well, perhaps it's my it may be my misunderstanding as to what it is that's being referred to, and if so, then we'll pass on that point. But
that's surely a reference to something like the defendant who advances positively dishonest mitigation after my years of service in the army, when he never set foot near a barracks.
If it's that, then it's not a good point. We must move on promptly. My Lord, in that very case, at paragraph 64, the Court of Appeal found, see the bottom of paragraph 64, that bearing in mind the amount of reduction of sentence that was already been achieved by the plea on a big sentence of 24 years, in the circumstances, we do not consider that double jeopardy carries any significant weight. Here, where a principal aim of the punishment is the public interest in deterrence, pour encourager les autres, then considerations of double jeopardy should take second place. Because the key is to uphold and preserve public confidence in the administration of justice. It's a very sort of alien concept to some of us, the concept of double jeopardy in circumstances where the defendant has chosen to fight the case, has gone through a process. If the judge has made mistakes and they need to be remedied and rectified in the Court of Appeal, nevertheless to have a reduction in the appropriate sentence that should have been achieved after the contested trial on the grounds of so-called double jeopardy is I used the word amiss.
Is double jeopardy a common law principle?
It's a principle which certainly applies because that's authority.
Some statute.
I think no. That is, I think, the authority on double jeopardy, and it's a common law principle. I recognise, and I've taken the court to the case already, that in the decision of Neil and Ryan, tab 8, that was the non-molestation. Apologies for still eating into the lunch in German. The case at tab 8, page P127. Lord Justice Judge does say in the sidebar passage at the end, and what is more, if the court reaches that conclusion when deciding the appropriate level sentence, the court must also reflect the element of what is sometimes described as double jeopardy.
All right, so that's binding on us. Right, so
My Lord, it needs to be reflected, but it can take second place. I didn't actually bring, there was a case with an appeal under the statute from the GMC, in which the GMC statute indicated that it was concerned with the protection of the public, and the language that Lord Phillips used in that case was that's where I borrowed it from, that where the principal